which I'm very thankful for. Honorable Justice Bhuyan and our learned panelists need no introduction. However, I would like to take this privilege to say a few words about them. Justice Bhuyan is a distinguished judge of the Supreme Court, known for his expertise amongst others in constitutional law. His father was a senior advocate and a former Advocate General of Assam. As an advocate, his lordship practiced before the principal seat of Guwahati High Court and appeared before Agartala, Shillong, Kohima, Itanagar benches of Guwahati High Court. His lordship also practiced before the Central Administrative Tribunal, Guwahati bench, and the Assam Board of Revenue. His lordship appeared before the Labour Court, Guwahati, various civil courts, and the State Consumer Forum, etc. Lordship was designated as a senior advocate by the Guwahati High Court in 2010. He was appointed as an additional Advocate General of Assam in 2011. He has been a judge of Guwahati High Court, Bombay High Court, Chief Justice of the High Court of the State of Telangana before his Lordship's elevation to the Supreme Court. His Lordship was also the Executive Chairman of Mizoram State Legal Services Authority and was closely working with the Judicial Academy, Assam, and National Law University, Guwahati. Justice Bhuyan has continued his association with the legal education. He's a member of the General Council as well as Executive Council of National Law School of India University, Bangalore. He is also a member of General Council of Maharashtra National Law University, Aurangabad. Our learned panelist, Mr. Nadkarni, he's a prominent senior advocate and a legal expert. He's recognized for serving as the youngest Advocate General of Goa. And thereafter, he was appointed as an additional Solicitor General of India. And thereafter, he's known for his extensive work in constitutional law. He hails from a family of lawyers. Both his son and daughter, they are practicing lawyers. His father-in-law was the first Advocate General of Goa. Mr. Nadkarni has always been very welcoming for lawyers coming from outstation, especially for SCORA and its members. We would like to thank him for his warm hospitality. Our learned panelist, Mr. Pawa, he's a senior advocate and a qualified company secretary. He's a graduate of Delhi University and was enrolled at the bar in the year 1993. He practiced before the High Court of Gujarat for about 32 years before shifting his base to the Supreme Court. Next, our learned panelist, Mr. Sanjay Basu. He's a founding partner of Aquilaw law firm. The moderator here, Mr. Soman Mukherjee, is also a partner in Aquilaw. Shauman Mohanty, I'm sorry. Aquilaw has been recognized in the Chamber Asia Pacific Guide 2026 with ranked departments and practitioners noted for their expertise. It is a full-time service law firm with offices in Kolkata, New Delhi, Bhubaneswar, and Mumbai. Its practice spans a broad spectrum of litigation and advisory work, including constitutional law, commercial and regulatory dispute arbitration, corporate governance, tax, and policy matters. The firm also specializes in a white-collar crime and criminal practice. I would also like to thank all the esteemed panelists for sponsoring this conference, without whose support it would be difficult to organize such a grand event, sir. The topic of the panel discussion is changing landscape of white-collar crime investigation. Very interesting and relevant in today's time. Now, without taking much time, I request the moderator, Mr. Mohanty, to begin the session, please.
A very good afternoon to all of you. Am I audible? Hello. Yeah, a very good afternoon to all of you here. First of all, I would like to thank and I'm grateful to SCORA for organizing such an amazing event, this conference, where all the lawyers, it's very difficult to find all the lawyers under the same roof until it's a court corridor or a lawyer's wedding or some family function. But all of us are grateful for this great initiative taken by SCORA. Before starting with the panel discussion, I would like to just lay down the premise for the discussion today. As we all know, white-collar crime investigations today are shaped as much by constitutional scrutiny as they are by enforcement urgency. Over the last decade, we have seen that there has been expanded statutory powers, aggressive asset attachment, increased arrests, and a dramatic rise in investigative activity. But we have also seen at the same time, there's been modest conviction rates. So we here will have a discussion to understand whether this model, the current model, is sustainable, constitutionally sound, and fit for the future. There will be 6 broad themes of the panel discussion, they being: number one, coercive powers and their economic impact, because we have seen increasing instances of asset attachments, arrests, curtailment of liberty and freedom. The second would be personal liberty and constitutional limits, where we'll be discussing the long incarceration in white-collar crimes, as well as some, in most cases, inordinate delays in trials. Then the structural shifts in investigative philosophy, where we always knew, or at least that was the theory, that bail is the rule and jail is the exception. How has that principle evolved under the present landscape? Next, enforcement outcomes and systemic reform. How do we bridge the gap between effective enforcement as well as constitutional safeguards? And last but not the least, cross-border and digital challenges, because with the advent of technology and the digital age, we see how India's ability to enforce economic offense laws beyond its borders. So without any further delay, I'd like to put my first question to my lord. My lord, data placed before the Rajya Sabha indicates that out of 911 prosecution complaints which have been filed by the Enforcement Directorate between the years 2019 to 2024, we have seen trial has concluded in almost 654 cases, of which conviction has been secured in approximately 42 cases for offences of money laundering. So the conviction rate is as low as approximately 6%. From a policy lens, my lord, we would like to know, does this call for greater prosecutorial discretion at the stage of filing complaints? And should public prosecutors in economic offences cease to be given greater institutional independence to assess evidentiary strength and public interest before proceeding with prosecution?
Thank you. A very good morning to all of you. I remember there was a book on PMLA written by an author from Bombay, a lawyer from Bombay, Akhilesh Dubey. And I had delivered in Tata Theatre and CPA one lecture on PMLA. I said that PMLA is a very potent weapon in the fight against, in the crusade against money laundering, which is a serious offense, having cross-border ramifications. But like a weapon in conventional warfare, too much of exposure of that weapon, it will lose its potency, it will lose its efficacy. So I said that there has to be proper discretion in applicability of the this particular provision. And I remember to have said that the investigative agencies must be very fair. People must not get a feeling that instead of targeting or trying to achieve the principal object, which is to prevent money laundering, the objective appears to be something else. So if it partakes the character of targeted investigation, and as you see, PMLA has got a severe, very, very severe consequences. It can lead to attachment of properties and arrest also. More particularly after that Vijay Madanlal Chaudhary judgment. So the investigative agencies will have to be very, very careful. We in the judiciary will insist that the procedure as prescribed under the law will have to be followed. The constitutional principles of fair trial, speedy trial, bail, the rule, jail, the exception, these principles would have to be adhered to. Unfortunately, what is happening in the country is that, like the layman, even the investigative agencies and unfortunately some of the law officers also, they tend to react as if grant of bail amounts to acquittal. This is the biggest problem that the people are facing. You are, in a case like PMLA, for example, maximum on conviction it is 7 years. Then if you keep a person in jail without bail for 4 years, 3 years like that, and as you pointed out, the conviction rate is less than 6%, what do you do? At the end of the trial, he is acquitted. First of all, he doesn't go for trial. If it goes for trial, then he is acquitted. How do you justify this prolonged incarceration? So therefore, in cases after cases, there's so many cases. I was part of that bench shared with Justice Oak. Of course, the other benches also. Repeatedly, while granting bail, we said that it may have consequences. 45 may be there, section 45. But then, after a particular point of time, it will have to give way to the higher constitutional principle of Article 21. So, what we are looking at is that, insofar as economic consequences are concerned, certainly, those who have violated the law, those who have caused ruin to the country, they must be prosecuted. But, while prosecuting them, you cannot deviate from the established legal procedure. This process we have developed years and years. Generations of judges have developed that. Let us not fritter away all these developments that the generations of judges have contributed. So my concern is this. But certainly you have a point, yes. And insofar as Prevention of Corruption Act is concerned, we need to have a social audit whether this act has achieved the objective for which it was enacted. Recently, this 17A was introduced, and we have a split verdict now. Justice Nagaratna says that it is a reincarnation of 6A of the earlier 6A, which was struck down in Vinit Narayan and all that. Then Justice Vishwanathan says he has gone to the extent of reading down appropriate authority to include Lokpal or Lokayukt. Now, one critic I saw, Vikas Singh, on the other day saying that this virtually amounts to rewriting the statute. So, prima facie, again, I am of the view, as a law student of law, that seeking the prior approval of the competent authority before you want to investigate itself may not be the appropriate. This will virtually amount to preventing, vetoing an impending investigation into corrupt officers. What we are trying instead ending up doing is that we are going after the small fish and letting the big players out of the net. This would be my opening remark.
Thank you so much, sir. That really puts things into perspective to start the session with. And we understand and we agree what sir just said, that there is a robust framework in place, but the enforcement is what matters. And effective, robust framework needs effective enforcement also. Taking a leaf from that, Mr. Nadkarni, my next question is to you. So we have seen in the recent past, there's always been this hasty conduct of investigating agencies in the white-collar crime cases, where they were very ready and willing to arrest. But in the recent past, this entire principle, this entire idea has been discussed, has been criticized, and increasingly courts have said that there has to be renewed focus on the power of arrest in white-collar cases, and the necessity to arrest has been discussed very widely. What is your take on that, sir?
I fully endorse what my Lord Justice Bhuyan said, and he rightly mentioned that the whole object of this act is sought to be sidelined in the process. There is absolutely no doubt that corruption is like a cancer in this country, and the money which you get from this modes, whether it is corruption, stealing, whatever it is, through some criminal mode, has always to be tapped and given back to the society. So the whole endeavor of the legislature in its wisdom was, when it was drafted by the Vajpayee government that time, and these are new legislations which have come world over also, was to get hold of the proceeds of crime. And the proceeds of crime is, that's why it defines proceeds of crime in, even if you get a property out of it, the value of the proceeds of crime, and that is what the money should come back to the society, is the object. Now, instead of going after the property, what the investigating agencies have been doing over a period of time, and the experience tells us, is they catch the person first and put him in the jail. Right? Now, remember, these are all white collar criminals. These are not some middle income group people and all that. These white collar criminals, they have their network all over the world. So they sit in the jail and the proceeds of crime are still being laundered all over the world. And it's most unfortunate that whether it is the government, investigating agencies and our courts have not been seeing this. Of course, Supreme Court for the first time came down heavily and, delivered several judgments. That too, after the lot of public outcry was there. And then Article 21 and all this was done. But the basic thing is that instead of, arresting a person, what about the ill-gotten wealth which he still rotates through his network and launders it and continues to do it? You have a classic example of this Unitech matter. Those two people sitting inside, they were inside. It took Supreme Court 2.5 years to realize that inside it was like a 5-star thing. They were having everything, whatnot, and still the money was being laundered. It's only then that they were shifted here and there and all this. See, today laundering of money is so easy, the digital network is there. So instead of arresting a person, if you let him out and keep a strict watch on him, and that is how the investigation should go on. So with great respect, the way it is going on today, Supreme Court has said several times, it's being misused for political purposes. That is there. Then you are simply arresting a person and putting inside. Then there are cases where ancestral property of the person has been attached. And what is the ground to attach ancestral property? Even if you want to recover the value of proceeds, you can't do it because the ancestral property has so many other shareholders. So the whole way in which the act has been administered needs a serious relook at the level of the government of India. And my lord rightly said that it's unfortunate that the law officers also take it, that it's a matter of that person has to be inside. So it can't be like that. The whole law has to be administered in a proper way. I wish some judgment of the Supreme Court someday comes down very heavily on this. They have only been saying it, but they have not been, directing it. So I hope they do it someday.
That's a very fair point.
No, I said yesterday something in Pune.
Yes, we saw that, sir.
Yes. No, I just want to add to what
Please, sir,
Nadkarni has said. In Arvind Kejriwal 1, Justice Khanna and Justice Datta, they said that right to arrest under 19 is justiciable. The very grounds. Then in Arvind Kejriwal 2, there was a difference of opinion. Justice Surya Kant, as he then was, said that the arrest is valid, but because of the prolonged incarceration, we are going to release him on bail. I differed. I said bail, he has to be granted. Arrest itself is illegal because there are two things. The need and the validity of the arrest and the necessity of arrest. An arrest may fulfill all the legal grounds required for arresting a person, but whether that arrest, just because the power to arrest is there, doesn't necessarily mean that you have to arrest that person. So in that particular case, we found that he was on the verge of, on the cusp of release in the CBI case. The complaint was lodged 2 years earlier. He was on the cusp of release in the PMLA case. FIR was lodged by the CBI 2 years earlier. He was not arrested. When he was about to be released in the ED case, the CBI steps in and arrests him. So this, I said that this is wholly illegal.
That's also become a standard procedure or practice. We have seen in a lot of cases where at least one or the other agency helps the other agency out. If you are letting him go, we'll take him in, like a lodge. But still, my next question is to Mr. Pava. So in cases involving money laundering and economic offenses, nowadays we see the corporatization of these white collar crimes. So more often than not, we see it's the individuals as well as the corporates. So from a policy standpoint, I would like to understand from you, are the existing legal tools adequate to ensure accountability and effective participation of companies in criminal proceedings, where physical arrest, as we know, is not possible?
See, for a corporate entity, the prosecution can be launched against the company, and we have judgments of Supreme Court now taking a view that prosecution can take place against the corporate entity, and there can be also imposition of fine in the judgment of Standard Chartered Bank. But we are all aware, under the PMLA in particular, you have section 70, which defines that suppose the company has to be prosecuted, then you can also prosecute the persons who are in the charge of the affairs of the company. Now, Companies Act also defines the managing director, as we all know. It now also defines KMP, key managerial personnel. And also, it defines persons who can be authorized by the companies for specific compliances. So, we all understand that the company is an artificial entity. It functions through its officers. Officers, right? Now, those persons are the persons who decide the affairs. And if there is some action which is criminal in nature, then those persons are the persons who ultimately should be hauled up. And you have enough mechanism, according to me, both under the Companies Act jurisprudence as also under the PMLA, to penalize those persons. And as I said, under the Companies Act, now you have stringent provisions defining KMP and the managing director. And there is no escape route. If the prosecution agency, if they are very serious to really prosecute, you have enough provisions to prosecute the persons who are in the hem of the affairs of the company. So you have enough tools, according to me.
Thank you so much, sir. Of course, we have seen from the days of the Satyam scam to today, because when that happened, we saw how easily the accused person could go scot-free. At least we are saying scot-free because he had to serve a very minimum sentence. But today the laws are so stringent that corporates as well as the KMPs think twice before they even get into such kind of conduct. So on that note, my next question is to Mr. Sanjay Basu. So with growth of specialized economic statutes, as we have seen, the PMLA, the Fugitive Offenders Act, then there is Benami Transactions Act, these governing money laundering, corporate fraud, securities regulation, as well as Benami transactions, which confer expanded powers and often depart from ordinary criminal procedures, like reverse burden of proof, the enhanced, in case of a bail proceeding, there's a lot of regulations that need to be followed. How do you think has the balance between effective investigation and individual liberty evolved? And what principles do you think should guide courts in preserving constitutional safeguards while permitting robust enforcement?
Thank you, Skoda, for having me here. Thank you, Asta. See, the offenses that we have seen in the past, which were covered by IPC and few of such statutes, were, I would say, were baby statutes, were baby offenses. With time, India grew. India grew into a huge economy. India opened up. Foreign companies came. Indian companies in itself, organic growth happened. And with it, a lot of different kind of offenses came into place, and new definitions of offenses were added. One of it was money laundering, then Benami transactions, many more offenses. The way offenses used to be seen by us when we were absolute juniors, there was Section 420, there was forgery, they were very, very basic offenses. Now, they have become like, we don't even look at it. Of course, we look at it. As a predicate offense, we look at it. But then it has grown to a different level, where there's a lot of money involved, lot of conversion of money from one identity into another, there is layering of assets. Lots of different, offenses have come into play which were not there earlier. Having said that, there are statutes which have come, like PMLA. PMLA is a major one, which the whole of India is talking. It is a major source of actually going after laundered money. But applying that statute requires a lot of responsibility, because that statute has given a lot of unfettered power to investigating agencies. Investigating agencies, I'm not saying they are doing a bad job, but then to keep, I would say, to keep a check on whether it is being implemented in the perfect manner, there should be there should be judicial intervention. While doing so, I feel there are 4 or 5 different parameters which can be followed. One of which I have made a note of it, so I'll read from that note. Distinguish between power of arrest and necessity to arrest. My lord has just now said that necessity to arrest is something which is different from power to arrest. You may have a power to arrest, but you may not need a person behind bars. Maybe he is cooperating, he has, all those principles which govern arrests. Second is, procedural safeguard must be interpreted strictly. Procedure is very important. While implementing an act, procedure, we can't just go and catch hold of a person without a procedure. There has to be procedure in place, and the procedure the investigating agency should follow strictly, so that no injustice is done to anybody. The third one is proportionality. We have seen situations where, couple of situations where, say, rupee 1 has been laundered, converted into rupee 5. Fine, you can actually go and attach that. But where that rupee 1 is distinctly separate from 2 more rupees which that person might have earned legitimately, why go behind that? So you can't really, attach something which is not POC and which is distinctly separate from POC. Third is ancestral properties, which Mr. Nadkarni had said. Ancestral properties of a person or properties which are prior to the committing of such offenses are a lot of time attached. Fine, there is law which says that you can remove that attachment, you can go fight it out, but then that takes a lot of time. There is delay in those proceedings. It's attached to the trial also. So by the time a person who might be enjoying his, say, ancestral property, he dies in that property with that property not in a position being sold, because it's not there. I mean, it's attached. So these are few of the basic principles which I feel are required to cover the special statutes, as we can say.
Thank you so much, sir. So what we understand is, with more power, to quote from the Spider-Man movie, with more power comes more responsibility. But here, coupled with more proportionality also, as well as the necessity part. Now, sir, I would like my next question is to Justice Bhuyan. My lord, from a policy perspective, do you see merit? Because we have seen with the advent of the new laws, the BNSS, we see there's a provision, a section about whistleblower protection. So do you think, my lord, you see merit in strengthening whistleblower incentive and protection frameworks in India to enable early detection and prevention of white-collar crimes? Because to date, we don't have the guidelines. The government is yet to come up with the guidelines. What is your take on it?
Actually, we have this Whistleblower Protection Act 2014. It is still awaiting pending notification. So, moreover, we need to not only safeguard but protect the whistleblowers because they do a lot of good at inherent risk of themselves. And in recent times, we have seen, unfortunately, many of the whistleblowers are being targeted. So this is one thing. Now, just parallel to this, certainly we need to safeguard the whistleblowers. Parallel to this, what I have noticed is a disturbing trend. We have two rights, if I may say so. One is the right to privacy, which we say is traceable to 21 Puttoswamy and all the subsequent judgments, overruling earlier judgments. Side by side, we have the right to know, right to information, which is not only traceable to 19, it is traceable to 21 also. An informed citizenry is the foundation of a mature democracy. To have a participatory democracy, our citizens must be informed. Unfortunately, what is happening is that the two rights, right to privacy and right to know or right to information, are being pitted against each other, as if there is an antinomy between the two. And I would put it this way, that there's no conflict or contradiction between the two. Both are necessary. The right to privacy of an honest citizen, as well as the overall right to know of the citizens, cannot be in conflict with each other. Having said that, whistleblowers are needed to be protected. Now, before I wind up, just one more thing. You mentioned about Satyam computers. Recently, what happened? I think Bad Boy Billionaires. There's a Netflix serial there, Bad Boy Billionaire. They also deal about this corporate scams. So I think one civil court in Hyderabad has granted an injunction, and recently that injunction was lifted. That reminded me, when I was Chief Justice there, a bunch of writ petitions came up for hearing before my court, all by Tech Mahindra. After this Satyam Computers went into liquidation, it was taken over by Tech Mahindra. This Ramalinga Raju, he had made a confession that to boost up his global image of his company, he had inflated the profits, etc. Now, based on that, he had filed inflated returns, income tax returns, and accordingly, he was assessed. In this round of this writ petition, Tech Mahindra contended before the court that this is not the real income. This is all inflated income. So, the assessment would have to be on the basis of the actual income. So, this was the petition. My bench, we were hearing it. Unfortunately, or fortunately, midway, I came to the Supreme Court.
Thank you so much, sir, for
After
sharing
this,
that.
I inquired back. I was told that High Court had allowed the petition and directed the assessing authority to redo the entire assessment.
Thank you so much, my lord, for sharing that interesting anecdote. Now, moving on to Mr. Pava. So, my next question is, we have seen that there is a growing concern that provisional attachment under the PMLA proceedings, particularly at the investigating stage, at the investigation innocent stage, can cripple otherwise functional businesses, where assets and money, bank accounts being frozen, all these things are happening. Is there merit in recognizing mechanisms such as substitution of attached operational assets with alternative security, as has recently been permitted by the Honorable Supreme Court in the M3M India matter, to prevent disruption of commercial activity and public interest projects, keeping in mind that it was made very clear in the judgment that this should not act as a precedent? Please, your take on that, sir.
The answer is yes, of course. So in all economic offenses, I take a serious note that we have to treat these economic offenses very, very seriously. In fact, Honorable Supreme Court in 2024 has taken the view that bail matters concerning economic offenses be viewed differently, much more seriously. In fact, the views expressed by the Honorable Supreme Court also goes to the extent of saying that in a 302 murder case, one person dies. Here, not just one family, number of families, they disappear. That's what is the consequence of a serious economic offense. But nevertheless, as Honorable Court, my lords just said, we are only considering at the end of the day that justice should be seen. My friend just mentioned in PMLA cases, 6% is the conviction rate, and trial is always endless. At the same time, you have serious provisions under the PMLA which talk about attachment. And I'm sure we all are aware that we have now section 17 where a proviso which mandated that you can take action for search, seizure, freezing, etc. only after the charge sheet is filed is omitted in 2019. So just please see section 5 said attachment, proviso first said after charge sheet or after complaint is lodged by the authority before the court concerned who is powered to investigate. Second proviso diluted that proviso substantially. But 17 proviso omission is absolutely takes the rights of the agencies to the next level. Because this, sir, says that you can search, you can seize, and if seizure is not possible, you can freeze. Proviso said that you can do it only after the charge sheet is filed under the schedule offenses or the complaint is lodged under section 45. All that is omitted now. So today, the ED can come to your home, to your office, anytime and say, look, we have right to investigate and search, seize. They can immediately apply seizure orders, freeze, everything can be put to a complete standstill. Now for the corporate entity, as I said, when we are answering on the tools part, you have listed entities, you have unlisted entities. In case of a listed entity, you have thousands of shareholders. If today your action, the ED's action, bring about a stalemate in the company, ultimate sufferer are those thousands of shareholders and other stakeholders, including the banks, because bank had huge exposure in the companies. Therefore, it is, we have, of course, you are aware, we have rules also under the PMLA rules, which provide for power to substitute the security. But that happens only after the confirmation takes place. The confirmation order, you have a length of 180 days, right? After 30 days to 180 days, any time, they may do, they may not do. So until 180 days, 6 months, there can be complete standstill. Your accounts can be sealed. You can't operate your bank accounts. Everything come to standstill. How do you operate? So therefore, Honorable Justice Narasimha in this judgment which my friend is referring to, took a note of this problem and called upon the ED and said that, look, can we find a solution? And the ED in this matter was kind enough to come forth and said, yes, sir, we can agree on substituting the assets. And then the court drew the mechanism and there were interim orders by which they were called upon to make the valuation, find alternative properties which can be attached by the ED, etc., etc., etc. But my point is, this is, Honorable Court also said this not be considered to be a precedent. According to my humble view, considering the impact which such actions, which has unbridled powers, given to the ED, I'm sure we need to really have a very serious view in such matters, and substitution should be a matter of course according to me, because ultimately, as a principle, because when you exclude no charge sheet, action can be taken, then draw this principle, draw analogy from rule 4, 5 and bring it the very first stage also. No sooner you want to attach, say what is the proceed of crime, the value thereof, give an option and give a right to challenge it. You can't withhold the challenge for 6 months and then say, nothing doing, everything has come to a standstill. Again, it's my view, therefore, that the way Honorable Supreme Court has indulged in this matter, it should be a matter of principle, as a matter of judgment, which I'm sure honorable judges would consider in appropriate case and draw some further analogies on it, sir.
In fact, in Hyderabad, at Division Bench of Mine, we had applied this principle. In Nimagada Prasad or something, there's a bunch of cases, Bharti Cements and then Nimagada Prasad and all this. We had applied this principle that ultimately at the end of the day, you are concerned with the proceeds of crime. Yes, the equivalent, have it till the, because this provisional attachment and confirmation of attachment, then you go to a tribunal, then the High Court, it will take a lot of time. In the meanwhile, concrete assets are being blocked up for with no benefit to anybody.
At this stage, sir, just to make a mention, sir, we have section 226 under the Income Tax Act, sir, a similar provision of seizure. There, Supreme Court has taken a very strong exception saying that, look, you can't do without granting an opportunity of being heard. You just can't overnight come and attach the accounts of the SSC just because there are some income tax areas. I think some such principles the Honorable Court perhaps or the legislature may have to bring in, work it out.
Thank you so much. That says it perfectly. Now, also because my lord was just mentioning about Bad Boy Billionaires, that series on Netflix. My next question is somewhere related to it, to Mr. Nadkarni. So, despite improvements in international cooperation, challenges persist in securing the return of fugitive economic offenders. At a policy level, so what do you think, what further legal or diplomatic measures could strengthen India's ability to enforce economic offense laws beyond its borders?
When you talk about getting a fugitive who is overseas, it naturally, involves another country. For example, from UAE, many of the fugitives have been brought back. That is because that government itself deported. But you have someone in London today sitting there, not just one, several of them, and they have not been able to bring them back. You remember the first of the case was a murder case, that Nadim Shravan, that Jodi which was doing music. One fellow is still there. The murder trial is held up here because of that. Gulshan Kumar's murder trial. Number two, there are other persons there. And they were roaming free until recently. And all of them, some of them are. So you have those countries where it is very strict. And for example, we got one of the underworld criminals from Portugal. The government of India gave an assurance that, he will not be hanged and it will not be this and that. And the charge sheet was filed saying that imprisonment is life or death. So they used it abroad, and then there were so many other proceedings. So first, our criminal law justice system should, build trust and faith. In fact, what has happened today is, it's only if the Supreme Court of India has given some kind of assurance, then they respond to it. But the assurance given by the executive side is not taken so seriously by many of the civilizations. I hope you are aware of what happened on a boat. The Italian Marines shot down some fishermen. They were arrested and they were allowed to go. And the Supreme Court, they had given an undertaking. So finally it went into, even when you deal with civilized jurisprudence, it takes a lot of time. So for that, you have to make your ecosystem of trial, etc., very firm. And I think it's not a very difficult task. If the government of India takes it very seriously, they can do it.
Very well put, sir. My next question is to Mr. Basu. Sir, parliamentary data indicates that out of over 6,300 enforcement cases registered under the Prevention of Money Laundering Act from 2014 to 2025, only 120 convictions have been recorded. What factors, according to you, procedural, evidentiary, or statutory, contribute to this marked disparity between investigative activity and the judicial outcomes?
You are talking of prosecution. I would go one step before that. I have a statistics which says that there have been 7,700 71 cases, ECIRs, which have been registered. And there have been prosecution complaints of 1,739, which is almost 1/7. Now consider a situation, this may not be, in a case, a prosecution complaint filed. In most of the cases, there are multiple prosecution complaints filed. It's not just one prosecution complaint. So they, naturally, I mean, it's investigative constraints which they have, where one set of laundering is investigated, and then a prosecution complaint, which is charge sheet in common parlance, is filed. In a case, there could be, and I have seen with my experience, there are multiple prosecution complaints in one case. So this 23% is, I would say, much lesser. I mean, it would not be more than 17 to 18% of cases have resulted in complete prosecution complaint, and then which has gone into trial. Now, lot of trials don't proceed because in a lot of situations, prosecution complaint is still being filed, and they are interconnected. So one trial cannot happen. Second situation is where they are being tried in different courts. So there's a PMLA court, which is a special court, and which is also investigating a CBI case of the same offense. But I have seen situations where the CBI case is in one city and the PMLA case is in another city. So there are overlapping of evidences, overlapping of witnesses, accused. So it's not just there has to be a simple process by which a prosecution complaint is filed. If a prosecution complaint in a ECIR is being filed, it should be a complete process. It should not be something which breaks. And again, it goes into another investigation, another prosecution complaint is filed. Indiscriminate arrests really stop a lot of prosecution complaints from getting into trial. Naturally, it results in stoppage of trial process. The whole structure needs to be relooked into, so that from a case to the investigation, result of the investigation to the trial, it is straight, simple, and simplified, so that the desired result. See, nobody can say that you don't need a PMLA case. You need cases so that you can really prosecute what has been laundered. But then the process has to be simplified. Numbers will increase automatically.
Thank you so much, Mr. Basu. And that's a very interesting point which you just mentioned, because we have also seen in our experience, in our practice, the fact that the predicate offense is registered under one jurisdiction under a specific court, whereas the PMLA offense has been registered under different jurisdiction. And we see the overlapping of jurisdictions, the entire judicial processes, where people may have to go through the parallel rigors of two different jurisdictions and two different statutes. On that point, Mr. Pava, my next question to you, in the context of multi-agency enforcement frameworks, where complex financial offenses often span jurisdictions and statutory regimes, what institutional or procedural mechanism can improve cooperation among investigative bodies to avoid duplication, enhance evidence sharing, and strengthen prosecution? You may also consider, like under the PMLA, we have that provision which says, as far as possible, both the offenses should be tried by the same court. In that light, sir, what's your take on it?
This is a problem which is being faced by the investigating agencies also. very honestly, as of now, I don't think we have a mechanism in place which gives one unified agency the entire power to investigate into different facets of the prosecution. In commercial matters, I have noticed you have broadly agencies such as CBI, you have SFIO, you have SEBI, and then now the ED. Interestingly, recently I was doing a matter in Supreme Court for SEBI, and they told me that the facts showed that somebody indulged into market fraud and disappeared. So under SEBI Act, sir, there were proceedings taken out, and up to the SAT succeeded, matter was going on in Supreme Court. So I asked the officer that what happened to this gentleman who has been ordered to pay some 100 crores odd amount by the order of the adjudicating officer, of which SAT appeal was dismissed and matter is pending in Supreme Court. He says, sir, we can't do anything in the matter because we don't have a mechanism by which we can bring that person back to India. We have informed the Ministry of Finance, and there is no further proceedings, no further action. I was really surprised, and I said, how this is possible? And I learned that there are boards set up by the Ministry of Finance. One board is known as some economic council, and it has a council of ministers which have been requested to work out a mechanism by which all the agencies can be brought under one umbrella. And one board is again a board where you have a central board of some bureau which is required to have a data of all the banks of the country, especially in relation to the fraudulent accounts, so that that agency can collect the data and pass on to the concerned agency. But the fact remains, as on current date, we don't have a mechanism by which one investigating agency can investigate and has the power to investigate into all ancillary and incidental offenses concerning a particular fraud. Let's hope either the government does it, because government has set up the panel. I'm sure they will be in the process of finding out some mechanism, or maybe the Honorable Supreme Court issues some directions. Because of this anomaly, a lot of people are escaping the prosecution, sir. So this is what I felt that can be thought of. Thank you.
Thank you so much, sir. Of course, we all dream of the day when the state police investigating agencies and the central investigating agencies align themselves with the same motive or the same aim of dealing with crimes and criminals rather than some other reason. Now, my next question is to Justice Bhuyan. My lord, white-collar crime investigations today appear to be shaped as much by procedural safeguards as by substantive allegations. What, in your view, are the most significant shifts in how such investigations are initiated, conducted, as well as scrutinized by courts?
In India, we have a clear-cut demarcation, stage prior to prosecution and post-prosecution. Insofar as the investigative stage is concerned, the role of judicial oversight is limited. To the extent that fair investigation is a constitutional right, the arrest, bail, etc. is there. It is only the judiciary actually comes into play only once the prosecution is set in motion. There, see, at the end of the day, it is for the prosecution to prove the allegation. It is as simple as that. It is for the prosecution to prove the allegation against the accused. And it must be proved beyond all reasonable doubt. This is the basic fundamentals. If not, then he is entitled, the accused is entitled to the benefit of the doubt. In some cases, we see the prosecution is unable to make out a case at the end of the day against the accused. So he gets a benefit of acquittal on merit. So the endeavor of the court has always been to ensure that the process does not end up becoming the punishment. This is the fundamental thing for which the investigative agencies, the prosecuting agencies must align themselves to ensure that the success rate in conviction, it is where if the success rate in conviction is low, the credibility of the investigating agency automatically will go down. That you are unnecessarily investigating people, prosecuting people, without there being legally admissible evidence. It is another matter that a person may remain in jail for some time, but that doesn't take away from the burden on the investigating agency, the burden on the prosecuting agency, that ultimately the burden is on you to prove the charges against the accused. So this is the basic substratum. But see, there is a recent book by the Supreme Court celebrating 75 years of its establishment. In this book, the Chief Justice of India, Justice Chandrachud, he speaks about the polyvocality of the Supreme Court. And according to him, this is a welcome development. He says polyvocality only endorses the diversity of views. It only recognizes or acknowledges the diversity of views in the Supreme Court, which is a welcome sign, and that should be cherished. On the other hand, in the same book, Justice Ravindran writes that this polyvocality is a serious issue. It's a very serious issue, undermining the credibility of the institution itself. Now, unfortunately, in India, we sit in benches. Other Supreme Courts, other jurisdictions, they don't sit in benches. So therefore, this conflict of views doesn't arise there. In India, we have on a given date 14 to 15 benches. Now, each bench, suppose, so therefore the question of judicial discipline, adherence to established norms, adherence to ratio, becomes very crucial, very important. Now, if each bench is guided by its own views of right and wrong, legal and illegal, then we end up having conflicting judgments, which sends out again a very wrong signal, not only to the trial courts, but to the high courts also. So this is one area is of serious concern. And yesterday in my speech, I said, it will be a sad day for Indian judiciary and by extension, our democracy, if the verdict in a case becomes a foregone conclusion the moment it is listed before a particular bench or a particular judge. We have to be on guard against this.
Very well said, my lord.
Just 1 second. This morning itself, Justice Corinne Joseph was there in the function, and there was a question asked, you asked the question, right? As to what should be a quality of a judge. I mean, this is what I'm paraphrasing. So there were different perceptions about it. Justice Joseph said that, look, when we take oath, we take oath by our constitution. So a judge who follows constitution is the best judge. So that's what my lord just said, that we have to only see the constitution. If you see the constitution, you can't have different perception, different views.
Just to add a rider to what you said, everybody follows the constitution. Question is about the interpretation of the constitution.
That's completely right.
But again, you can't interpret the constitution on its head. That is distortion of the constitution.
But thank you so much. We understood at least process not becoming punishment as far as investigation is concerned, as well as the court procedure is concerned. My next question is to Mr. Nadkarni. Currently, sir, we see, like as recently as the last week, we see courts discussing the ambit and scope of investigating agencies' powers on the search and seizure of digital devices. Agencies often seize entire phones, servers, which inevitably expose confidential communications and irrelevant private data. From a policy standpoint, as well as being a part of judiciary, Do we need to mandate the use of independent forensic examiners to segregate relevant evidence before it reaches the investigating officer, ensuring that privileged data remains protected? More so in case if we talk about lawyers or any other profession where there's a confidentiality attached to such information.
The answer, in short, is absolutely yes, 100%. Because today, from an industrial age, we came to an information age. From an information age, we have traveled by way of a paradigm shift to a digital age. And now, you have an unruly horse called the artificial intelligence. So you never know where you're going to head. See, it's not just the pictures on the Instagram or something which is done. That's nothing. That's hardly 0.1% of it. If tomorrow an evidence is produced in the court and the judges are made to believe that, then it's a very, very, very serious thing. Today we are talking about applying, artificial intelligence in the system of administration of justice. What is the limit? The session just before this was, where Justice Dipankar Datta was presiding, was on artificial intelligence, law, lawyers and artificial intelligence. So tomorrow at this rate, will you allow judgments to be, articulated by the artificial intelligence? So if you ask me, forensic independent examiners are absolutely indispensable and they should be inextricably interlinked to the very prosecution process right from beginning. Because whether it is police, customs, excise, ED or CBI, none of them know anything about digital intervention. They are not aware of it. And that is how many cases are lost only because they do not know anything about it. So the answer is yes.
Couldn't have said it better. Thank you so much, sir, for putting it so succinctly. My next question is to Mr. Basu. I would like to understand from you, sir, looking ahead, because we have discussed almost every aspect of investigation, as well as the robust framework that we need, as well as the judicial overview of white-collar crimes. Looking ahead, what broad policy reforms do you consider essential to ensure that India's approach to white-collar crime investigation remains effective, fair, and aligned with the constitutional values?
It's a very good question. See, the first principle I would want to be, put in place is inter-institutional trust. ECIR or a FIR is lodged, it goes to the police or the whoever the investigating agency is. It is investigated. It is whether a person has committed a crime, charge sheet is filed, if or a prosecution complaint is filed, or it leads to a FRT or there's no other proceeding. In this whole process, if the agency does its job best and the courts start having trust on those agencies, it will lead to a simple process by which an act or the purpose of an act will be fulfilled. That's number one. So there has to be a proper inter-institutional trust so that the investigating agency is fair. The courts will not look into, if a matter goes to the courts will not look into it with suspicion. Whoever is being pursued and accused also understands that, yes, I have done this crime and this is it which the court will help me coming out of. Number two would be, which is connected to the first one, is rebuilding this trust. If this trust is rebuilt between the agencies, even the accused, the complainant a lot of time goes to the court to say that my matter is not being investigated properly, right? If this trust, this whole rebuilding of credibility of the agencies and the credibility of all the institutions involved in it would lead to a simple, clean system. Second is necessity to arrest. Necessity to arrest and power to arrest should have a completely distinct position. As his lordship has laid down, that ground of arrest needs to be given in case of an accused in an ED case. Similarly, arrest should not be a standard procedure. Arrest should happen as a resort only to stop whatever to stop something from being, the principles which are laid down. Third would be all these proceedings to be followed constitutionally, following the basic structure of the Constitution. And again, a level of trust between the court, the investigating agencies, and the people involved in it.
Thank you, sir. Now, I would like to just have concluding remarks from my Lord Justice Bhuyan, Mr. Natkani, as well as Mr. Pawa. Then we will open the floor for audience question and answers. My Lord, please.
I thought you would start. Not this way. Actually, we have said what is required to be said. See, these are serious offences, and therefore these offences need to be investigated and, if required, prosecuted with all the seriousness. It should not appear that investigation is selective or targeted. If that happens, then the very purpose of having the special legislations are lost. People will give many examples, and they are there on record that for various reasons, though somebody is accused in a serious white-collar offense, is not being prosecuted because at the right moment he has shifted sides. This is a serious thing. Everyone needs to look into it. Can the agencies be permitted to be selective? One day or the other, this issue will have to be dealt with by the court. Secondly, as rightly pointed out by all of us, perception may vary, but at the end of the day, when we apply the principles of law, keeping in mind the overarching constitutional principle, there can't be multiplicity of views in the Supreme Court. After all, the court is there. The very existence of the Supreme Court is for upholding personal liberty and human rights. There is no other. Supreme Court is not established to justify executive actions denying liberty and violation of human rights. That is not the reason for existence of the Supreme Court. Once everybody understands this and puts in place this doctrine, there can be divergence of views. Certainly, amongst 34, 35 judges, it is bound to happen. With the legal community is there, it's bound to happen. But there can't be divergence on views on the very fundamentals on which our legal system exists. Once this is done, all other peripheral things will fall in place. Credibility of the system will increase. then people outside our country, jurisdictions outside our country, will not hesitate to extradite people who are wanted to be prosecuted in this country. Because in the case of Abu Salim, Portugal insisted that because of your system that we have, kindly ensure that there's no death penalty. So once we do this, fall in place, I'm sure all the countries around the world will take note of this, and there will be mutual reciprocity on this ground. So there I stand. Then rightly so, we have unlike Russia or other countries, we have separate investigative wing, prosecution wing, and this I think is good. It falls into a place of separation of powers, and we have everything in place. All that we have the laws in place, we have the infrastructure in place. All that we need to put in is that keep aside our political or ideological views and stick to our constitution. That's all.
Thank you so much, my lord. Thank you so much. Mr. Natkani?
I fully endorse what my lord had just said. See, there was a politician in Mumbai, I won't name him, but our name is there in the public domain. The allegation against him was that Iqbal Mirchi, Memon, Dawood Ibrahim and all that and blah, 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 and the properties have been built. This property at Worli is built, that property as Worli is built, everything. Suddenly that politician changed sides. He joined a particular party, and thereafter the report is filed, be summary in the court, that, everything is, we have checked and everything is spick and fine. The magistrate accepts the report and it's given complete finality. Properties are released, everything is done. I mean, is this the way our system of governance should go? The higher courts which are there have unfortunately remained blindfolded to this particular thing. It has happened in front of them. Justice Gawai's bench in several things, I think my lord was also a party to that. In some Telangana matter or some, they said you are using ED for political purposes. But they only stopped at that. I wish they should have gone further. And if it is to be hit, it should really hit at that time. I mean, see, what the government does, every misdoing is not something the Supreme Court is not there to cure it. But what I'm trying to tell you is that, as my lord rightly said, and so well put, that you follow the constitution. But if the constitution is not followed, then there are constitutional courts, called the High Court and the Supreme Court, who are supposed to act. It is not the magistrate who is going to accept that particular report. He is not a part of the constitutional setup. You can't wait until a PIL is brought about and, somewhere, and God alone knows before which bench it will come. Today, unfortunately, that is the system. In 80s, when we were practicing, that was not such a thing. It was about, this judge is pro-tenant, that judge is pro-landlord, like that. Today, it's something different. So therefore, as my lord said, Supreme Court must speak in one voice. And the High Court should also get the voice, because in ED cases, you saw over the last decade, none of the High Courts were giving any bail. I'm glad now they have started waking up and giving bails. But yet, even today, some judges are very scared. Because if you are scared, you should not. You have got so much, protection under the Constitution. The independence of judiciary is something which strikes at the root of the matter. So those are my views. I mean, I'm very open about it. I've said it last year I said my blood boils the way, things happen. So I'm saying today it is not boiling, it is settling down. But I only hope that, things improve further.
Thank you so much, sir. Sir has very subtly and a very brilliant way put before us the idea of washing machines as we know it. Now, Mr. Power.
See, the landscape of an investigation has to undergo a change, because the offenders are getting smarter day by day. And economic offenses is, as I said, is very, very serious offense. So I am for one of the view that yes, the changes being made in the law, giving powers to the investigating agencies with promptness, powers to search, seize, freeze, etc., are necessary, keeping in view the rule of law. But yes, The issue is about implementation. We are all concerned about the selective implementation of the provisions of the law. Therefore, in investigation per se, the changing landscape, all positive, good, welcome. The issue is about its implementation. I mean, that's something which, as we said, the Parliament has to look into it, provide for principles, provides for checks and balances, and the Honorable Supreme Court, the High Court should have to perhaps lay down some principles, some parameters to utilize those provisions of law in the right perspective. That's what I would like to say. Thank you.
Thank you so much. Mr. Basu, your concluding remarks.
Adkani said about High Courts giving bails, but that bail is even coming after a very, very long time in custody, which actually, I mean, it defeats the whole purpose of giving a bail to a person. For an offense which has a maximum sentence of 7 years, you can't wait for 1.5 years, 2 years to give a person bail. So even if high courts are giving bails, it's coming too late. It should change. Thank you.
Thank you so much. Thank you so much, Mr. Basu. So now we open the floor. Okay. Okay. Starts. Yeah. Starting with you. Yeah, please.
Good afternoon, everyone, and it was an absolute privilege listening to this very, very illustrious panel. And I speak for all the criminal lawyers here, so a quick comment, if I may, and a quick question to my lord and to Mr. Nadkarni. Firstly, for all the lawyers I speak, I wish we get Honorable Justice Bhuyan as a bench for our matters. That's one. Given that he's such a great conscience keeper of the court itself. But my question...
The review is still being awaited.
Yes, that's right. But very, very quickly, and I know everybody wants to go for lunch, so I'll be very quick. My question is to my Lord Justice Bhuyan and, of course, to my senior, Mr. Nadkarni. All of the seniors, in fact, even Mr. Pava mentioned the fact that there should be checks and balances, and my Lord has also mentioned that in the remarks. My question, therefore, Lordship, is this, that shouldn't certain stringent consequences, perhaps, in the form of, let us say, costs, follow even when it comes to, say, illegal detention, illegal arrests, and also wrongful attachments? Till such time, my question, therefore, Lordship, is this, that till such time solid accountability comes in, and there are some costs or consequences that ensue for the officers that do some of these things, perhaps we will not see a change, which is...
I think you have hit the nail on the head. This is the issue, actually. We don't have a provision, criminal provision like that to hold up accountability. The only thing we have is slightly like we have malicious prosecution, but that's not going to help. So I think in an appropriate case, the court can certainly look into it. If there is malice in the arrest and continued detention of a person, certainly he has a right to be compensated. His reputation is damaged beyond repair, so he needs to be compensated. And unless this is done, this malady of this illegal arrest and selective targeting of arrests will continue, which brings discredit to not only discredit to everybody and all stakeholders. So you are right. I hope you will be the lawyer in some cause where the court can seriously think about bringing in this kind of consequences.
So your thoughts?
I think, apart from what my lord has said, costs, etc., when imposed, suppose you impose 10 crores cost on ED, it's again we are paying it. They are not paying it. So I think the court should go a step further, and because there is no point in inflicting such a corrupt or, an high-handed officer on the population of this country. So the faster you get rid of such officers and the inherent powers of the court which are there, for example, Article 142 of the Honorable Supreme Court to do complete justice is precisely for these kind of cases where there is no solution. And if you do it on one officer, the entire country will, all the officers will get the message. But I wish it is done someday by someone.
Thank you so much. Please, Nipun.
So my question is centering around the polyvocality. We have Section 37 of the NDPS Act, on which also contain the twin conditions. We have a judgment of the Honorable Supreme Court on that. We have section 43D subclause 5 of the UAP Act, on which there also is a judgment of the Honorable Supreme Court. Now we have section 45, and notwithstanding Nikesh Tarachand, we have the new amended version of the section 45. The cusp of everything, the central question that I'm placing for your consideration is this: does the length or the duration of custody would at any point of time dilute these twin conditions that the Supreme Court is grappling with judgment after judgment? But there comes the issue of polyvocality. What is good for a 37 NDPS Act, what is good for a 43D, is perhaps not so good for section 45. The question is why? And I understand my lord may have some constraints answering that, so my question would again be redirected to the learned senior counsel, sir. Thank you.
You know, first on the principle of polyvocality. There is absolutely nothing wrong in having polyvocality in the courts as such, because it's an institution which has to ultimately give out its views. But unfortunately, in our legal system, do you recall the judgment of Indira Sani? It was 9 judges. All 9 judges have written separate 9 judgments. Each one of them claimed that theirs is the majority. Some in Jivan Reddy's thing, there are some common things, but otherwise that is it. That judgment runs into how many pages? Several, thousands of pages. Look at the American Supreme Court. All 14 judges sit. The judgment is hardly 3 or 4 pages. The entire law is laid down. So, polyvocality principle is something different. Today we have 2 judges, then 3 judges take a different view. Another 3 judges or 2 judges says, no, this view we don't. Constitution bench. Constitution bench, then it takes a view, and then, so I said, no, refer it to a 7 judges. From 7 it goes to 9. Today in Supreme Court, 11 judges matters are pending. Property dealers cases, mining matters, etc. are still pending. But what happens to the cause? What happens to the principle of law? Based on those things, several matters are pending in other courts. So the polyvocality, it is only for the expression of views and correction of its own errors, then it is fine. Because law is a dynamic, it's not a static thing. What was the law some time back can't be the law today. Today it's gone completely in a different thing. So if those things are there, then polyvocality for those purposes welcome. But if you're going to just pamper your ego and give it, recently we have seen in Supreme Court so many reviews coming up after the judges have retired. So that's also not a very healthy thing. I mean, it has to be a lot of responsibility for this, because the administration of justice rests on certain principles. So those are my views. Thank you.
Can I have a question?
Yes, please.
Good afternoon, everybody. And I have a question for anybody who could answer it. I mean, what is your opinion, sir, on the point that insulating the investigating agency from the political interference would be one of the answers? And secondly, in some jurisdictions, like we have a prosecutor being a part of the investigation, like and a lawyer, generally in US, I guess. So would that be of also help in our Indian scenario? I mean, these are 2 questions which I had. So anybody, Natkani sir?
In Israel, there's this prime minister called Ariel Sharon. Are you aware of it? A sitting prime minister was sought to be prosecuted by their police. Is it thinkable in India anywhere? Forget prime minister, even to a chief minister by the police? No. Supreme Court tried it. Supreme Court first said the investigating officer and the law and order officials should be. Then they came out with the police establishment board, Justice Radhakrishnan judgment, police establishment board, and they said the SP should do it. Now, do you really believe by that judgment you have insulated the police from the politicians? The SP, is he going to do anything else other than what the Home Minister or the Chief Minister tells to do? I mean, so therefore, some of those judgments, sir, really need a relook, and you should come down very heavily on it. Some of the best judgments of the Supreme Court is, grounds of arrest, or even when you take him to a police station, take him for medical checkup. Then record, videographing, all these are part of judicial judgments. And subsequently, they have come into the, legislature has incorporated them into law. So it's only when the judiciary, and that is the final protector of the rights. Today, if Article 21 is surviving in the Constitution, only because of the constitutional courts have jealously safeguarded it, despite the aberration in between.
On the grounds of arrest, I'm sure even now I see matters coming to Supreme Court. Whether ground A is the grounds of arrest as per Supreme Court judgment or is not a grounds of arrest. And I mean, there is no answer, unfortunately. Now, on the insulation part, see, as I said, law is in place. Law is in place. It's a matter of its implementation. As my lord just said some time back, you have two broad branches, investigation, prosecution. In investigation, nobody can touch. Even courts cannot touch. Courts cannot interfere. That's the law by the Supreme Court. So the investigating agency can investigate the way he feels appropriate as per the law. And no sooner he is reported to a cognizable offense, he has to register a crime and proceed further with the investigation. So your answer lies in the books, actually. The problem is implementation. No sooner complaints lodged against a person, could be anybody in the country, he has to be investigated. But difficulty is implementation.
See, there are police officers whose name we have not even heard of. They are very, very good police officers. They will be some housing board, police housing board, or some like that. And a group of police officers will everywhere. They will be there in law and order, everything. So this is again an area. We see the faces of only those police officers who are close to the powers that be, the establishment. Good police officers are sidelined. So therefore, we make it a point that why every time a petition comes, sir, please send it to the CBI for investigation. What CBI? CBI is nothing. They are drawn from police officers from the different states, different establishment. And there are good police officers in each police force. There are good officers in Goa, there are good officers in Maharashtra, everywhere. There are good officers. So only thing is that we need to protect, make the police immune from political interference. Only then they will be proper. That is the key.
Thank you so much, my lord. So I think now,
just one question.
just the last question.
Yes,
Please, let's
because
make
he
it last question.
mentioned UAPA. So I wanted to ask Justice Bhuyan, what is your view? Because there is a judgment of 6 years being incarcerated in custody, 2 accused being denied bail when the trial will not end in the next decade or so. So there is a polyvocality on that, and is that an aberration, or how do you see that?
This is a very, very live issue, and I would not like to stick my neck out and say something. I will say, when the occasion arises or when a particular case comes, I'll speak through my judgment, what I hold.
Thank you so much. Thank you so
Not
much. So,
foreclose that option by speaking out publicly.
so what today's session tells us is the answer does not lie in expanding the powers, but refining its exercise. And also to always keep the constitutional values in mind while it may be during the investigating stage or the judicial stage. And with that, I would like to first of all thank the panelists, Justice Bhuyan, Mr. Nadkarni, Mr. Pava, Mr. Basu. Thank you so much for giving us a very insightful as well as engaging session on the changing landscape of white-collar crime. And thank you so much. Let's now head for lunch, I'm sure.
Before we close, Skora would like to felicitate the dignitaries. So I request Kanu Agarwal to kindly come and present a memento to Honorable Mr. Justice Ujjal Bhuyan. I request Govindji to kindly present a memento to Mr. Nadkarni. I request Jayant Khan to kindly present a memento to Mr. Pava. I request Vivek Kumar to kindly present a memento to Mr. Basu. I request Vinamr to kindly present a memento to Mr. Mohanty. Thank you, everyone. Thank you.